All right, and welcome to Mock Trial Basics, the series where I kind of give you the basic overview of everything that you need to do for the nuts and bolts of any sort of mock trial situation. Today, the most basic of basic direct examination. Direct examination is, frankly, the easiest part of the process for the attorney. Really, the way a direct examination works is you take a copy of the witness record, the police report, the accident report, whatever the case may be. You decide what parts of that your witness can explain, and you ask them the questions to explain that. You're building your case. Now, direct examination, in order to be successful, follows a couple of keys to success. First, you have to think about what you want to prove. Direct examination is going to be very different if you're a criminal defense attorney compared to a criminal prosecutor. One has to prove their case, the other is trying to poke holes in it. Number two, you have to read the witness statements. As you'll see in a second with the examples, it makes sense to prepare your questions side by side. Take your witness statement out, put it on your table, take your legal pad out, and write the questions next to them. Oftentimes, what I do when starting out is color code, highlight, or use a numbering system. So you can make a number one next to the statement that you want to elicit with question number one, and so on and so forth. That way you can be sure that you've got all the answers that you need. Lastly, remember, this is direct examination. It's not cross examination. You have to ask open ended questions. You're not allowed to lead the witness during direct examination. For more about that, watch the video on cross examination and you'll see the difference. Let's take a look at some basics. You always, when you start, have to establish the identity of the person who is the witness. Remember, this is a witness that you have called. So it's somebody who you should have a relationship with, who, ideally, you have practiced these questions with several times. So a lot of this should be rote memorization. You always begin by having the witness state their name for the record. Then, for any sort of trial, it's important to ground the jury in where the person was in relationship to the case at hand. So, where were you? Once you have established the beginning of the story, direct examination becomes very easy. It's normally a series of questions like, well, then what happened? Well, tell me what happened next. What did you do after that? What did you see? What did you hear? So we're asking a series of where and what questions to build the case. It's like someone giving you a summary of a short story. We want the witness to give us the nuts and bolts. Who happened, to who, where, and when. The why, well, that requires a little bit more. Let's look at some examples here. A very easy early example, which I have here on the slide, has the attorney's questions in white and the responses in red. As you can see, begin by asking the normal question that you'll always start with. Please state your name for the record. That should always be your first question. Then we ground our case and our witness in the time and the place, immediately focusing in on the facts that matter. Once we've done that, we can begin our series of open ended what questions. You need to let your witness be the star of the show in direct examination. You get to do more in the cross. Don't worry. Let's look at one more detailed example. Here I have side by side a witness statement on the left, a very typical witness statement, you might receive in an automobile accident case. And then when you call that witness, a series of questions on the right. As you can see, as you look at the two side by side, oftentimes what you're doing is simply going line by line, deciding if you need that fact or not. If you don't need it, cross it out. If you do need it, think, all right, what question would I need to ask this person in order to get them to say what is on that report? And that brings me to my final point with a simple direct examination. This is a simple direct examination, by the way. We're not dealing with any evidentiary issues. Those will be in some other videos. You have to remember to ask yourself, did I ask about everything on the report that helps me? Did I build my case? Make sure that as you ask your questions, you're getting the responses that you need. If not, you may need to adjust your questions on the fly. As you get the facts that you need into the record, cross them off of your sheet so that you know that you don't need them. So that's the basics of direct examination. It's easily the simplest aspect of any trial for an attorney who has called a witness. We'll get into much more complicated issues as we proceed.